Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. Welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger. I would like to say greetings to Athatar. Good to see you. Private joke, Athatar. Love you much. Kelly G, greetings. Taya Harper, thank you for this being your first time. I hope it's a good experience. Taya, since it's your first time, let me tell you a little bit about me, Toothless. I'm 65 years old, I'm retired, and I came onto YouTube because I was inspired. So I come to try to uplift fallen humanity, but a lot of people don't like what I have to offer. I don't have a lot of jokes and putting down and mistreating people. I came to uplift people, and I come with 65 years of experience. And I tell things from my point of view. I love piano music, and I play the music a minute before people come in because I don't get a big crowd. So I try to give one or two people an opportunity to come in before I get started. But trust me, I'll start by myself, and I'll end by myself if need be, because I really love what I do, and I do know one day somebody is going to need what I have to say. And the people that has followed me since I started, and the newcomers that have joined and returned, they like what I have to say. And so it doesn't take a lot of people to change anything, because as we all know, there's only one or two worker bees in any crowd, no matter what crowd you're in. All it takes is for somebody to be willing and to hear, because a lot of us don't know that we have choices. I am an Asiatic female, and they know we're known as Black people. Black is a actual legal status, a political status, and it has no affiliation with life in the human family. But we've been taught to use that all of our lives. 12 years ago, I went on a journey to find out who we were before we were slaves, before we were called all of these names. And I found the answer for myself. And I did it by looking at scholars on YouTube, researching, and it has really been freedom for me. If it's nothing else but the freedom from my thoughts and my mind. And that's what I try to offer people in what I do. I'm going to be talking tonight about what happened on Friday at the Young Thug trial. And it was very disheartening, to say the least. And it's a lot of trickery going on. And that's why it's very important for us as a people to start actually trying to, you don't have to know anything by memory, but start familiarizing yourself with things by reading. It is very important that you read and you try to retain whatever it is that you read, or take notes. And that's what I find. It's better if you take notes. Take notes. And the biggest thing about knowledge is not having it all in your head, but knowing where to find the answer to whatever question you may have. Also, when you're seeking answers to questions, you also must know that you got to start with a timeline. Everything that you know that you do, that you want to prove, it has a beginning, and then it has up to the moment that you're seeking the answer. So you also have to do your timelines. But I'm going to start on with what I've put together. I look at different people, and I look at so many different people. And I tell you, in looking at those people, I really have learned a lot. I've learned a lot about YouTube. I've learned about a lot about support. And I've learned that the main thing is, if you really want to support someone, you probably have to just listen to what they have to say and do whatever you're going to do. Sometimes you make comments, you don't know if you offend the people, and that is not your intent when you're making comments. You don't know how deep these people are into whatever topic they're into. At least I don't. And I don't pretend to know. I just know me. And I know that the purpose in which I make a statement is to contribute to the chat, not take away from it, or not to insult the host. I see a lot of good coverage on this case, and I believe my coverage is equally as good. I don't have the editing skills, so mine may be a little verbose or very long, but I want you to understand what you're looking at and what you're hearing from a practical point of view. Here I'm looking at what happened on Friday. I don't know how many look at the Young Thug trial, but people all over, the people that I watch, have thousands of people looking at their coverage, and the news stations. There is a language that lawyers use, and it's called legalese, and they did that language for a reason. And that's why it's so very important that we can't give legal advice, and we can't represent other people unless we're licensed, because that's the way this country do things. They take your God-given talents, your skill, whatever it is you bring to the table, and they monetize it. And they monetize it by charging you licensing fees and making you become licensed. And that's kind of sad, but that's the way it is in this country. A lot of people call this country the land of the free and the home of the brave. I call it the land of the free and the home of the slave. And that's just my personal opinion. There are a lot of things here that they don't allow us to say on YouTube. Sometimes I get confused what we can and what we can't say, what would be considered free speech and what would be considered violations of policy and guidelines. And it's all seems to be sometimes a form of censorship. But if you had your own business, I guess you would make up your own policies and procedures the way you would want them. So what you try to do and what I try to do is comply to the best of my ability. Sometimes I miss the mark, but for the most part, I try to comply. I'm a cusser and I love cussing, and they allow us to cuss. They really do. We can cuss and call each other all kind of ugly names, but you know, since they're trying to commercialize more, and since I want people to really hear what I'm saying, sometimes I'll use a cuss word or two, but not as often as I used to. And I cuss not for the lack of the vocabulary. It's just that coming from where I come from, my daddy cussed like a sailor, and I loved it, and I couldn't wait to get grown. So that's why I cuss, and I know when and how, and to make it fit any conversation. I don't cuss and attack people because I'm not a fighter, and I didn't come here for that. I came here again to help uplift. Now, when you look at this story about Young Thug, when you look at, I'm going to have to talk about somebody that's dear to somebody that's dear to me. And not so much as the person, but their actions are dear. But when you look at Fani Willis, and I have to start with her because she's the DA, and her mission with all of these RICO cases. And it started back when she was an assistant DA, and she worked under, I believe his name was Paul Howard, and at one time they were not going to prosecute the teachers, and then at another they decided to. Looking at what happened between she and Nathan Wade, and listening to the different hearings, and especially the commissioner's hearings, and I've covered that I would suggest that anybody, whenever you get some free time, just really go listen to those hearings and to hear the millions of dollars that falls into the hands of the judiciary and the sheriff, which falls under the judiciary, the clerk, the county clerk, I would imagine that's who that is, and the superior judges and the solicitor generals, which handles their misdemeanors. So they call theirs different titles. But when you look at the money that falls in their hands, they have an item-lined budget that they go to the commissioners for to get the money. But when they get the money, they say they are constitutional officers and they don't necessarily have to use the money for the purpose in which it was granted to them. So they have, I know the DA has like a $36 million budget, 36.6. And then when they had this time going through, when we had the virus come through, they got this big sum of money, $75,000, to be split between 4 individuals and in the judiciary. And so I don't know how they split that money, but they split that millions of dollars. And then Fonnie Willis received another $2 million for SA kits for past people who had been assaulted and they needed to test. She gets state and federal grants and county money, plus the state also helps her budget. So we really don't have a real accounting, and this is true for all of our cities. So let's get this perfectly clear. I'm from Dallas, Texas, and we're not exempt from controversy. I'm only covering this because this is a big story in Atlanta right now. This is a place, too, that's Fulton County's predominantly ran by people, as most would call, of color. Asiatic individuals is what I would call them. But what type of individuals are they is what we need to really be asking ourselves. And that's why on my thumbnail, if you read it, I just wanted to know, could this be the faces of the culture of corruption that is spoke about in Fulton County? And I was looking at a board meeting the other day, and I'm going to do a video about it. I be having all these great ideas in my mind what I'm going to do, but my body tell me, no, you're not going to do all of that. And so I don't do it. And that's why I don't envy anybody for all the people that they have, all the money they receive. I would love to have people. I would love to receive donations more. But I'm happy with what I have because I'm going to give you all that I have, and that's what I give you. Out of the abundance of who I am is what I give you. And I don't have any more to give. I be tired. I be, just don't have it to give. So I give what I can and I give my all. And that's what I will continue to do. But yes, the ARPA funds, exactly. That was the money of the $75 million. That's true, Kelly. But it's so much more money that these people get that's unaccounted for, because they had the ARCA funds as well, and the ARCA was, they said like the whale ARCA, because it was so big they just called it ARCA. But that ARPA is one too, or it was called something with a D. So it was, they were saying 2 different funds, but there are federal grants that these people get. And what it does for me, it just shows me how this system has been in place all along. Okay? But we've had an Asiatic man for the past 20 years doing the same type thing. So it just shows me it doesn't matter if you're a male or female, if you're considered in the legal statuses, black or white, no matter who you are, if you have absolute power, you will be corrupted. Because as we know, it's not just a saying. Absolute power corrupts. Absolutely. And that happens with human beings. Some of us are able to discipline ourselves, and we may fall off the beaten path, but we pull ourselves back. And you can see how corrupt it is just with the autonomy of individuals being their own bosses on YouTube, and the lengths they'll go through to destroy people that are coming up and doing as great as they're doing. They'll start destroying them by talking about their family, talking about their children, exposing where they live, other personal business. So, it's true of all human beings, and we can't get away from that. But going back to this story, I was looking and researching, and I found this little news clip that I'm going to share with you guys. Now, this stuff that happened between these young men of Young Thug, they were, they said 2014, 2015, and it, dates back before that because they were younger than that, before 2014, but most of the things that they're talking about, these guys were committing crimes, it looks like, on their own, but they all grew up in the same neighborhood. And so they all are friends. Young Thug was one who happened to have his talent take him before great men, and he was able to get out, so to speak. And when you get out, doesn't necessarily mean that you move out. And, you could have a residence somewhere else, but, your roots is always going to be with the people that you grew up with. And so he tried to maintain relationships with people who were not able to give up the street life. I say not able because I think one element is missing in all of this, and something that we should be seeing a lot of testimony on, and maybe we will on the defense side, not necessarily on the prosecutors, because of course they want a conviction. But the elements of drugs that these young men were using, and then the lack of education, where you're locking up the educators. So what can you do? I've already explained numerous of times about the school board, and their philosophy is to find you people exactly where you are and make sure that you stay happy in that state, a docile group of people. We're called minority because that means we haven't reached the age of maturity, and it is looked upon by most of the world that we are not mature enough to handle our own affairs. And we show that every day because all we do is bicker back and forth with each other, and we refuse to come together and learn the policy and the procedures that run this country so that we can become better people and do what all other people do. But that's another story. But when you go back, this article here that I'm going to play is 6 years ago. It was like 2018 is what it says, I believe. 6 years ago, and when you look at the date, it's 2018. So when you go back to March 8th, 2018, there was a gang, and they said they have a hierarchy of gangs, and I want y'all to hear this story, and I'm here to tell you, I didn't hear YSL or If Gang, none of that mentioned. Now, I did hear one of the other gangs mentioned, but I want you all to hear what the sheriff at that time had to say, and I want y'all to see the community leaders that were here then, but we didn't notice Fonnie Willis going to them when she was seeking re-election. She went to the old ministers of the old Baptist church. She didn't go to these community activists who went to ministers as well to try to help reach some of these young people and bring them into some type of help. So, let me play that for you guys. I want to make sure that the music is not too loud when we play it. I think it's down enough. Now, I think this is very important because Adrian Love and Fonnie Willis, they made their campaigns on gang violence. They were going to get rid of the gang problem. The gangs were taking over. But I want y'all to hear now, both Adrian Love and Fonnie Willis ran for DA in the 2020 election. Period. Cycle. Okay? And both ran on gang violence. Now, you're going to hear, I don't hear anything about the gang that they're speaking of today that they have in court. And I want to know what happened to this gang and the other 144 gangs that have been, they said, noted in the county of Fulton and the city of Atlanta. So it would cover all of their suburbs as well. So here we go.
With gangs, they're a problem all over Metro Atlanta.
Atlanta police tell us that there are nearly 150 gangs just in the city alone. And gangs are behind many of the crimes like carjackings and car break-ins. Fox 5's Morris Diggs joins us now live with a closer look at the #1 gang that's terrorizing Atlanta and a group who wants to do something about it. Morris?
Well, okay, so do you live or work in the city of Atlanta? Has your car window been busted by a thief looking for a weapon or for your phone? In my exclusive report, the Atlanta chief names the #1 gang her investigators say are responsible for the mayhem. It goes by the initials DFW. Police who attend community meetings from one end of town to the next will tell you the crime they're trying to slow down is organized by and large by gang activity.
If you have to ask the question, why should I get involved? If you don't get involved, this terror that we're witnessing is coming to a neighborhood near you.
Michael Langford, Derek Bozeman, and other community activists announced a program to get Atlanta area pastors involved in an effort to grab a youngster and turn that youngster away from a gang. And when you listen to Atlanta's top cop, you'll get a pretty good idea just how big a task that could be.
We have files on 145 different gangs in the city of Atlanta.
We've learned there is a gang hierarchy. The #1 outfit goes by DFW. What is that? It stands for down for whatever.
A couple of the founding members were Charlie and Isaac McDaniel. And I suspect that those names resonate with a couple of you. They were involved with and committed a murder.
The McDaniel brothers, when they were both teens, got locked up for some serious time as a result of a murder, killing a mature adult man after they learned he was about to alert authorities that he believed the pair was responsible for numerous car break-ins. Chief Shields says while the two co-founders are behind bars, DFW remains potent.
They primarily operate on the Joseph Boone corridor, and where they've really turned their attentions to in the last year, 8 months, is Zone 2 high-end cars. You see the corridor, they go up, you go in the parking garages, you commit a theft from auto, and you shoot back down to where their home base is. I believe that you can say fairly that a number of the armed robberies they're committing are tied to the guns they're getting out of stolen vehicles.
Langford and Bozeman vowed to do whatever they can to help the APD chief.
We're here in partnership to make Chief Shields' job a little bit easier by cutting off the numbers that end up coming to her in the first place.
Back live now on Joe Boone Boulevard, a two-pronged approach, the chief tells me. The first one is if there's a teenager and there's a chance, she wants to try and get that teenager into community activities, whether that be Michael Langford and Derek Bozeman or Police Athletic League. For the adults, she says the main cog, 22 to 26-year-old, she says they've got to be hit hard with gang charges out of the Fulton County DA's office.
Okay, that is what the chief at the time decided. Thank you, Taya. That is what the chief at the time decided. And if you recall, Miss Timpson said that DA Paul Howard had a program for gang preventions, and she came in under that program to work with the teenagers in the communities where there were gangs. But I've never heard them mention the DFW gang. I also have a young man who tried to leave the gang, and he was shot and all kind of things happened to him, but he survived, and he's yet out of the gang, and he was able to change his life. What he's doing today, I don't know. But I brought that up because I believe now this gives more credence to all of the rumors that go around that Young Thug was targeted because of his millionaire status. You know, for a woman to go after an ex-president, and I'm not saying whether he is guilty or not guilty, because from my investigations and the videos that I've shown, Atlanta did not certify at least 247,000 plus ballots. So I can't say, and that's going before the court, and as much as Fonnie Willis say that train is going to keep on moving, well, I think that's just the song, because the appeals court did an interlocutory appeal. They granted it, which means everything stops. It's like a stay when you file bankruptcy, or a stay that we're most familiar with hearing, stay with an execution, meaning that's not going to happen today. So we don't know when this is going to happen, when they're going to hear the case, when they're going to decide the case. But we do know this, is that nothing is going to happen in that area. Now, I've heard some people say they can't believe that Judge McAbee said that some things were going to still go forward. Well, I believe it because I looked at and shared in a video why they're going forward, because Mr. Harrison, Floyd, and Miss Cutie are questioning those ballots and the validity of them. And so he's allowing them to put together how it's going to be done. And that was the hearing that I shared the other day, that he's giving them until, I think they said the end of July or something, is when their experts would be available. Because the state, of course, is saying that that's going to take thousands of hours, totaling up to over $1 million, where this young man who's representing Mr. Harrison Floyd said, no, it's not going to take all of that. Their people are prepared and they're ready to come in. And so that's interesting, because he's going to rule on that, but he's giving them the go ahead to put it together, to put the motions together for him to rule on. So I really like Judge McAfee and the way that he appear to stand for something. Now, we know it's not all of nothing, so it can't be all bad and all good. And there has to be some good with the bad, and there's going to be bad with the good. So we just don't know what we're going to draw and the luck of the draw. Going to Young Thug, because we're going to look at this trial, most of it, on Friday. And so we want to go ahead and get time in. Giving you a little introduction. There's this person that they've been talking about throughout the entire trial. The state is saying like it is their number one witness, and he's going to really tie Young Thug into this to show why this RICO case should be a RICO case. And then they said that there are 3 elements that must be proven to tie it in to make it RICO. None of us have seen the RICO yet appear in this courtroom. Perhaps RICO will, I don't know. But with this witness, the state was so upset I believe they knew what they were doing. I believe that the judge knew what they were doing, and I believe that they knew it before they did this charade. I heard Young Thug's father, and I don't know if his word is bond or not, but that's his son. I love the way he spoke of his son and the history with his son, and he told it just like a mother. He didn't have to guess and look up in the sky or the ceiling. He just spit out, my son's birthday is, my son is this, my son, and that touched me as a mother. So I'm just going to say that I don't know if any of this stuff is true. And he said that he has receipts for whatever he's purporting, and we'll see that sooner or later. But one of the things that we do know is Young Thug is not a convicted felon. He's been held in jail since his arrest 2 years ago. And he's been held without bond because they say he's this notorious kingpin leader of this notorious street gang, YSL. But all of the people that have committed the horrendous crimes, including their number one witness that they were banking on, has been walking around free. A lot of the gang members that they said that were gang members that has committed crimes autonomous from Jeffrey Williams, Young Thug, all of that, they have actually let them walk free all of this time or gave them plea deals. So here you have Mr. Woody. And with Mr. Woody, they said that he was going to do this. He's done so much horrible stuff. He did things for the gang. He did this. Well, a year ago, an interview that he gave to 2 officers that are not known to be good officers. As a matter of fact, all of the officers pretty much that the state has brought as their witnesses have been caught in lies under oath, which is called perjury. Now, I don't know if they will suffer under the penalties of perjury, but they have been caught in making false statements under oath. Well, Woody says that he would say anything to get out of trouble and not go back to jail. Anything. And when he started his interview, he told them about his attorney, Mr. Melnick. And the police officer acknowledged Mr. Melnick was his attorney, but she didn't give him his Miranda rights that we heard, nor did she ask him if he wanted his attorney. They just talked that was his attorney and kept going for 3 hours. Well, the state contacted him last Friday saying, we want you to be, in this trial. And let's go Friday before last, because last Friday is when all the kerfuffling took place. But on the week before that, they contacted him. And he said he had been telling them that he's going to plead the fifth. And the reason he's going to plead the fifth, I don't know if you guys remember, but I did a video showing y'all about Gaither and how dirty she was and how she didn't show up at that federal hearing. She went before the magistrate, but she didn't come back to the hearing to correct when the judge found that those 2 officers lied under oath. There was a question about who removed the weapon. So she never showed up, and they just kind of let that go. Well, the state is telling him that they would give him immunity. To me, that was a bully tactic, and it's almost like kidnapping. Because most people that get immunity, they go seeking immunity. They're asking for it. And they either grant it or they don't. In this particular case, because he kept saying he was going to take the fifth, and they know the law, they used Georgia's code to offer him use immunity, meaning that they won't do anything to him for what he has to say, but he must testify. And they did that the morning of him supposedly appearing, and the judge signed off on it. Now, what nobody talked about was the fact that he did have a lawyer. And so they're going to make it sound like the state is that this man told them that wasn't their lawyer and all of this and all that. And they didn't ask him any of those questions under oath. And they're making these statements boldly, and they're making statements that's hearsay, and everything else would be speculation with any other situation. I'm making up this idea that somebody said that the state was going to hammer him, so he changed his mind, which all of that will come later. What we're about to see, I want y'all to just look at this for real. If you get a chance, if you can continue to look or listen. And I'd like for y'all to just, express your opinions inside the chat if you can. And Asatar said, yes, go Mavs. As a Lakers fan, I could never cheer for the Celtics. Okay, Asatar is kind of weird like that. He can never cheer for the Cowboys. So, go figure. But I'm a home team person, so I understand him going for his home team. I don't understand how he hates the Cowboys so much, but he can't stand the Cowboys. And this is cowboy country. So here we go. We're going to start out with, now that they're calling him to the witness stand, and y'all going to hear that he had been down there 1 or 2 days. But this is very interesting. And I wished everybody in America would look at how this criminal injustice system is really working. And I really wished every Asiatic mother would look at this to see that, the sisterhood that we think we have or we would like to have, it's just not there. These women are heartless. It's as if they don't even have a feminine ounce in their body. I don't know what they act like, because we have honorable men. But it's just unbelievable. And to me, it all ties back to the monies that the DA office gets, the Superior Court judges get, and how they don't have to really give an account for those funds. And so we'll just take this thing as far as we can take it and funnel all the money we can funnel and do what we need to do. That's my opinion. Doesn't mean that's what they're doing. But it doesn't make for much sense to think any other way. Nothing about this case has seemed above board. Everyone calls it a circus and a clown show, except for the players on the prosecutor's side. So let's hear as Miss Hilton, and I can't stand her condescending tone and how she tries to talk to these people. But let's hear her explain to the judge this before we get started. I'm using Fox 5 Atlanta's live coverage. I look at a lot of good people, but like I said, in viewing people now and listening to them, it's just safer this way for me, because I like their commentary and everything, but I don't know where people are in life, so I'm just going to keep it simple for me. And I want to thank Fox 5, and I want to thank the government for the Fair Use Act. And that's what we're going to do. Under fair use, we're going to watch most of this hearing. I'm going to be skipping around so we can hear the important parts. Here we go.
yesterday evening, the state received a email from John Melnick with Mr. Steele and Mr. Sharp copied on that email. Mr. Melnick advised that he represents our next witness in this case. Prior to receiving that email, the state had spoken with our witness on multiple occasions in preparation for trial. After yesterday, at about 5 or 6 p.m., whatever time I received the email, he advised that we need to cease all communications with his client. However,
his client is
Mr. Kenneth Copeland.
okay.
However, his client is not, there's no open pending litigation. We were operating as a witness. And so Mr. Melnick advised, I don't know if he wants to be present or not, but that he had court at 9 a.m. before Judge Krause. And so I'm bringing that to the court's attention. The state did offer Mr. Copeland use immunity in this case so that anything that he testifies to in this particular proceeding will not ever be used against him. Your Honor has signed that order, and so we are ready to move forward. However, I did want to bring to the court's attention that Mr. Melnick did advise that he was his attorney and that he was present in the building. I believe wanted to either address the court, but
Okay, well, if he's inserted himself in that particular respect, he needs to probably be here. So can we send somebody up to Judge Krause's to inquire? Because, or is he here? Or is he outside?
I have not seen him yet. So
is Mr. Copeland or his counsel present?
Mr. Copeland is present in the courthouse, yes.
All right. Where's Mr.
I saw Mr. Melnick this morning. I think he's in Judge Carnes' cell.
Oh, Mr. Carnes.
Okay, can we see if we could find him, please, and have him tell him that we're about to call his client?
I'm not sure if any of Mr. Sharp, Mr. Steele has. I do not have his phone number.
Okay. Well.
And while we're waiting for that, I do have 2 other issues.
Hold on, let me. Deputy Avila, can you ask one of your colleagues, or Deputy Ham, can you see if you can go up or have one of your colleagues go up to Judge Carnes' sales and see if we can, 1, either get him down here, or 2, ask Judge Carnes' sale when he would be available. And tell him that we also have a witness that we need to call, okay? All right, sir.
And then next, Your Honor, while we're waiting in that pendency, Mr. Copeland does have prior criminal convictions. The state did not see in any.
We might want to take those up if he's got counsel, okay?
Okay, well,
So,
I'll wait.
Let's wait till his lawyer is actually here, so we can take up those issues if he does have counsel, okay?
Yes, Your Honor.
All right. I'm just going to reset. That's in place then. Sir?
Good morning. Can I just step out while we're recessing? Is that okay?
Yes, sir. Deputy Avila, can you ask one of your colleagues, or Deputy Ham, can you see if you can go up or have one of your colleagues go up to Judge Carnes' sales? Okay.
May I approach?
You may.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 245507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker. And we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yes, Your Honor.
All right. And Mr. Melly, you are correct. I did go ahead and sign this morning. I'll make a part of the record the court's order giving him use immunity. Okay.
Good morning again, Your Honor. So first, let's give a timeline of events. Mr. Melnick spoke of speaking with Mr. Don Geary. I would believe.
What does that have to do? Let's cut to the chase. Okay.
So
I mean, all of that. It may be maybe historically.
Because I want to make sure the record is clear as to what Mr. Melnick said as far as his representation of him, especially as it relates to him being a witness in this case.
Okay, all right.
So
I'll let you fill in the background.
Sure.
Okay, go ahead.
So when Mr. Melnick, I believe, engaged with Mr. Geary, Mr. Copeland had at that time either two open pending cases, because this would have been in 2020 or 2021. At that point in time, he had open pending charges with the Fulton County District Attorney's Office. Since that time, those cases have been closed, and therefore Mr. Copeland does not have any open pending charges. Therefore, we have not spoken to Mr. Copeland previously when he had open pending cases. We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, We resubpoenaed him again last Friday, which was a week from today. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or if Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was that
now, if you're still here and you're listening, I want y'all to hear her use the word, I believe, he stated. I believe. I want y'all to just remember that statement, I believe.
that he hadn't spoke to him or that he wasn't his attorney. At that point, we continued to engage in conversation. Mr. Copeland engaged with us. On Monday, we reached out to Mr. Copeland to see if he wanted to come down to do witness prep. We did not meet on Monday. On Tuesday, we thought that he was going to get called. He came down here. We spoke. He asked us questions. We answered his questions, and we've moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he's a witness in our case. Yesterday at our final prep session, we spoke with him. It was about 1:00 in the afternoon in the courthouse. When we left the room that we were meeting in, I saw Mr. Matt Shard in the hallway. As we left, we had our greetings. And then it was not until 6:00 last night that I received an email from Mr. Melnick, copied Mr. Shard and Mr. Steele on that email, and advised that his client was going to plead the fifth. In the state's conversations with Mr. Copeland, he had some concerns, and we had told him just in general conversation that we would give him use immunity to.
Okay, she stated he had some concerns, but they say he never told them that he ever wanted to plead the fifth. What was his concerns about if it wasn't about pleading the fifth? And the judge knows this language, and y'all just should see how this works and how they railroad people every day. And people think that lawyers, get paid off and stuff like that. No, if you don't know the trickery that goes on in a courtroom, this too could be you. So just listen to what she's saying.
To testify in the trial. Once we received the email from Mr. Melnick last night, we moved forward, Your Honor, drafting a motion in order to give Mr. Copeland use immunity in this case. 24-5-507, Your Honor, lays out that it is the state's purview in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding.
And what they decided was then to literally kidnap this young man and rope him like cattle, because he may have immunity in the state's case where he has no pending charges in the state. But his issue is he has some issues with the feds, and they didn't move forward on those charges, but it doesn't mean that they can't move forward on those charges. And I'm not practicing law. I'm not giving legal advice. I'm telling you what you can read for yourself. If you research, all you got to do is research. But listen to what they're telling him. So they're telling him that now, and they probably didn't really tell him that. They saying they told him that. But when they decided to give him use immunity, I'm sure they didn't tell him that. I think that's something they did, and then they made it look like they were doing him a favor by giving him use immunity. But because he is a career criminal, and he's also been entangled with the federal government, he know the game is not that easily played. So I truly believe this young man, even though they got him the world's greatest liar, and he is a criminal, But I believe him when he knew what he was talking about when he said he wanted to plead the fifth. But let's keep listening to her in this double talk that they do.
And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5.
Now, do anyone in the chat or in the bushes, in the trees, on the beach, in the sand, in Aruba, in Belize, in the sky, wherever you may be, do anyone really believe if that man would have went to them and asked them to give him immunity, the state would have given him immunity? Just ask yourself that question. Do you really believe that?
07. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
That respond, Judge?
Yes, you can, Mr. Miller. So, Mr. Melnick, here's the...
In my opinion, this lets me know that the judge knows that all of this is wrong because he has discretion. He's supposed to be an honorable man. He's supposed to be a referee. He's not supposed to practice from the bench. And he's supposed to be non-biased. If he know now what he just heard, that they contacted him without his attorney being present, and he in fact was his attorney, why didn't he call him in and ask him questions about his attorney? And if he were asked, did he have an attorney or did he want his attorney involved? He's letting the state speak for this man who's going to walk in this courtroom in a moment. I want y'all to just take note of how they do things. All of these things are wrong. That's not the way it's supposed to work. But if you don't know your rights, and if you don't claim your rights, then you don't have rights. So you gotta know your right. You got to. And one of the rights we have is the right to remain silent. And you get an attorney, because they went to the same law schools and they had the same Law 101 classes and they know the legalese language. We don't know the secret language of lawyers. Doesn't mean we can't represent ourselves, but if we choose to do that, then we have to practice that same thing. We got to know when to speak and when not to speak, and speak only on what needs to be spoken. No additionals. So let's keep going and let's hear this from his attorney, because a judge should have said, then he can't honor that, but he's going on with, I signed the paper. Like that's the last word. Okay, you signed the paper, but you did it and they didn't know. So now you know, unless you knew. Okay?
Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Coming up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir.
The judge, in my opinion, is very prejudicial. Listen to the conversation he's about to have with this young man as if he is an attorney and he comprehend everything he's saying. He's not talking to him as an individual that don't have comprehension of the legal system, in my opinion. But just listen to the things that the judge says to this young man.
No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? I need 2 copies of it. Actually, 3.
Your sign.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposal.
The judge is so rude to Mr. Steele, Mr. Shard, Mr. Matthews, Mr. Weinstein, Mr. Bott. It is unbelievable. The only one that he seemed to have a semblance of respect for is Mr. Harvey back in the back. He used to be a civil rights attorney, and he has a lot of big cases. They said that he's so good they even have a rule named after him. He's the only one that the judge seems to give any type of respect to. But he's very, very, very rude with Mr. Steele and Mr. Shard. And before I seen him be so rude to Mr. Matthews, I just knew he was very prejudiced because of the way he mistreat them. But he's very biased because they're interfering with the monies, in my opinion, that they're all abusing from all of these federal, state, and county grants. That's just my personal opinion. And I have a right to that opinion. And in Fonnie Willis's case, it's been proven there have been some odor of mendacity, lies, and proof of misappropriations of funds.
Order.
But I signed the order this morning, though.
I meant the manner in which it will be filed will not be made public.
Okay. All right. Which copy's been given to Mr. Copeland? The order pursuant. All right. All right. Do we have extra copies of that? Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter. And state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness, they've identified you as a witness, they've determined that your testimony is needed.
Notice how he said that's how we, and caught himself and went with as a due process. He's practicing from the bench on the side of the state. And that's just the bottom line. You know, whoever loses the case has to pay big money. Big money. So just keep that in mind. I would ask you all to familiarize yourself with your state constitution, civil procedure for your state, criminal procedure for your state, and rules of evidence for your state, and then go look at the federal rules of civil procedure, criminal procedure, and rules of evidence. Most of the federal rules will coincide with your state numbers. No matter what state, they're going to be close in, facsimile. But just listen to this, y'all.
Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege.
If you notice, he didn't tell him the other remedies that he had up under his discretion. Wonder why. And then the Fifth Amendment right comes under the federal Constitution. That's part of our unalienable rights. Unalienable.
Done said. However, the immunity's been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay. You're taking the Fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's giving you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then...
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways. Like, you testify and then you use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
Now, I believe at that point in time, he believed that him saying he can tell him whatever he got to tell him was that he could tell him he's going to plead the fifth. Now, I don't know if that's what he thought or not. But the judge, to me, didn't make it right. And the judge didn't tell him the state is not going to prosecute you. But what he know in his head and why he was doing that smile was that the feds can. And he had already said to them he was not going to testify. He'd take the fifth. He shaved his head, and he's prepared to go to where he know he's going to go. Let's watch and see what happens.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. I will formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially...
Can I speak to my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what. Why don't you step outside and talk to Mr. Melnick? All right, can we summon Mr. Melnick and Mr. Copeland, please? Come on up, Mr. Copeland.
Oh, I thought y'all could hear me. I was reading what they said. Some of the people said Judge Warris is the problem. He can't lie. The testimony has to match his original statement. Uneducated about what, Morgan? The legal system? It don't say you must speak English. I don't recall over and over just like the others. He definitely couldn't say I don't recall. Judge, you know they did stuff without his attorney. People get attorneys because they don't understand the law. Nothing they did should be valid. That was my point. This trial is uckery. Laugh out loud. Samson. This is what the different people all over is saying. In his interrogation, Lil Woody told authorities about several crimes that occurred, crimes that were about to occur. He's at work, Bojangles, on Buford Highway, player. I don't recall. Anyone notice there are more guards in the courtroom? And these kids want to join gangs. Just speaking gibberish when she asks questions. That's still testimony. The state don't know what they talking about. Susie, when you don't understand something, you just fill in the blanks with fantasy and mind reading, right? So here we go. Let's hear this.
All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So, are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in. And
now this is what he's facing out in the free world, because everybody's calling him a snitch because of that tape that was leaked and all the stuff he was saying. But he said he would say anything to get out of there and not go back to jail. And he's been working with the police for years and years and years. And they know that. So that's nothing new. So they said he can't be charged for past crimes, only perjury. He can free the guys, bro. Get up there and spin like Bobby Miles. Someone said at Mookie, them guys got other charges. Being subpoenaed and having immunity, two different things. Cameraman. Rambo. I interned for a criminal defense attorney. What's your qualifications? Contempt. I don't know, COS. He got a subpoena for court. Woody don't have any charges. Judge about to take advantage of his power. That's what I say. You got to clear that up, because most people aren't that legal system savvy. The star-studded witness can't want help the state, and they know that. That's why they won't call them. The Fifth Amendment don't matter. He has immunity. Ural pissed. Ural is the judge. What he mean the Fifth Amendment doesn't apply? Someone say he walked like a snitch. Someone say he better humble himself. Judge was a DA. And then they said he had a GUN charge. So let's go and see what happens when they get the jury.
we'll go ahead and take your testimony, okay?
All right.
All right. What is it, Mr. Steele? Does our witness need to be excused? Yeah, sir, go ahead and stand outside, please, if you wouldn't mind. We'll call you in just a minute. All right. Mr. Copeland has left us. Yes, sir. What's your pleasure?
Morning, Your Honor. Good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now. That's why I raised it. But if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State. It's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal 375. It's in Division 2, 1983. Also Waldrop, which is Waldrip, versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. Oh, that's wrong. 829, 2005. And Your Honor, what I'd like you to do is the state has stated today, and Ms. Hilton told me this last evening, I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone on the defense side. But Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God forbid the killing of Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 in the morning, Mr. Copeland is on video, audio recording. With Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin, and then Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They had investigated. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside of that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's do let's deal with the issue first. The first issue of the notes. Okay. Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steve is basically saying is that Mr. Copeland's given a few, he said 5 statements. And that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady?
We do not have any written notes, Sean.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional notes, then I'll change the terms of my consideration on that issue.
Your Honor, and I'll get you the case in a moment because I don't have it at my mind unless someone else does, but oral statements must be reduced to writing if they're Brady by the prosecutor.
Yeah. But I think they're saying to you that the only statement that they have that's Brady is the one statement they turned over already.
And Your Honor, furthermore, in addition to that, in our conversations with Mr. Copeland, he didn't give us any different information than what is contained in the 6 interviews that defense counsel has had since 2022. So there's, outside of this one sentence or this one piece of information which we gave, our conversations were not.
There's nothing. Are you telling me that there's nothing that that needs to be reduced to Brady?
Correct.
Produces Brady.
If there was, we would have reduced it and sent it over.
All right. Okay. All right. Let's talk about prior convictions. Where's Mr. Melnick? Can you have him come back, please? All right, Mr. Melnick, I wanted you to be here for the this part of the conversation in regards to your client, because these are prior convictions. Okay. All right.
Your Honor, Mr. Copeland has a total of 11 convictions, Your Honor, prior convictions. However, based on 24-6-609, we believe that only 4 of them will be able to be discussed during the pendency of this case. The state has not received, and if any defense counsel can correct me, any notice that they wanted to use any convictions greater than 10 years old. And so I wanted to put on the record the convictions that are greater than 10 years old. Again, I did not see any notice that any defense counsel intended to use these, so we can
or the state's intending to use any of them.
Or the state's intentions to use any of them, so that we could have argument on those. So the convictions that I believe should not come in are as follows: 09SC82479, which was a September 1st, 2009 conviction.
For?
That one was for theft by taking.
Okay.
Enter an auto and other charges. Oh, no. Would you please for that? Okay. I just want to make sure that he didn't plead to. You know, in all candor, Your Honor, I believe he did plead to giving false info. So So for the 09 case, he did plead to giving false information. So they would be able to use that for the limited portion of the fact that he did plead to giving false information.
Yes, that part would be.
That part would be.
Would be admitted.
The next case we have, Your Honor, is 10 SC 87662. And he pled in 2010, but he ended up pleading to a misdemeanor. He pled to misdemeanor theft by receiving. The next is 10 SC 96.
10 SC 96.
938.
Okay.
And that plea was taken on March 7th, 2011. And the charge was aggravated assault and possession of a firearm during the commission of a felony. And then the next one is 12 SC 110195. He pled to this in August of 2013. And he pled to entering auto, several counts, misdemeanor criminal trespass, misdemeanor obstruction, misdemeanor theft by taking. And then on that same day, he also pled to 12 SC 113315.
Now, this is the man they gave immunity. This is the man they let walk free up until now. And this is all of those plea deals they gave him with all of the crimes he's committed. And they want to get rid of gangs. So how do they get rid of gangs? Give them all plea deals and put them back out? I don't understand. Somebody help me understand.
He pled to that on August 13, 2013. And there he pled to terroristic threats, aggravated assault, and battery. Then, Your Honor, he also had another case which was null prost, which was 12 SC 113001. And another case which was null prost, 13 SC. Oh, excuse me, this was a re-indictment of that 12 SC case. So the number was 13 SC 120161.
What kind of cases were those, madam?
Those were, it was a possession of MDMA and possession of marijuana less than an ounce. And the 13 SC was a re-indictment.
All right.
And so we believe the admissible convictions, and I can put that on the record, Your Honor, would be 15 SC 136794, in which he pled to that in December of 2018. And the charge was theft by receiving stolen property. The next is 20 SC 176851. And he pled on January 25th, 2022. Sure. The indictment number or the date? 20 SC 176851. You're welcome. And he pled to possession of a vehicle with an altered VIN and misdemeanor obstruction of law enforcement officers. Next is 20 SC 176912. And he pled on January 26, 2022. And he pled to possession of a controlled substance, Schedule 1 or 2, with the intent to distribute. And then last is 22 SC 182134, which he pled to on June 29, 2023.
One more time, what was that last number? I'm sorry.
22 SC 182134. And he pled to possession of a firearm by a convicted felon. And that was on June 29, 2023. And you're right, there's also a federal indictment. I do not, but he pled to that federal indictment in 2015. And so that indictment would be right. I'll get you the federal indictment number.
Have you shown these the non-qualifying and qualifying convictions to defense counsel?
I have not.
Can you let them take a look at it?
Oh, they have. Oh, yeah, we did provide.
We do have to qualify. We did work, but we have a disagreement about what's qualified, what's not qualified.
Okay, what do you have a disagreement as to what?
Well,
which matter?
Okay, thank you, Your Honor. First of all, we are looking through the court's records. Okay, Mr. Steele says he has it. We did file a motion of intent to impeach with convictions over 10 years old, so we're going to have to address that. But specifically, two of the convictions that the state says are over 10 years old, I disagree with, and that's because the statute reads from my understanding of the statute, and I think the plain reading of the statute, the clock is from the last incarceration.
Is it either or?
Well, it's the one
that's the statute. How's the statute?
The furthest in time. The 10 years has to elapse from the last incarceration. When that comes into play is when probation is revoked. When there's a split sentence, and then probation is revoked. And I can get you the cases. But Your Honor, 12 SC 110195, as well as 12 SC 113315. We would agree that the plea was entered over 10 years ago. However, on the court's records, the probation was revoked on 2/21/15. He was in custody at the time, so he's been incarcerated on those charges. The purpose of the statute is that the person has to maintain a history of lawful behavior to reestablish that they are not essentially a convicted felon. And
which statute are you talking about? Just so I can pull it out. But which one are you talking about?
I don't have the numbers. This is the impeachment by prior conviction. 609B. 609B. So, Your Honor, the statute says or release from confinement, whichever is the later date, is what I was referring to in the statute, the plain language of the statute.
Thank you, sir. Ms. Hilton, I am in possession of Mr. Steele's notice and Mr. Sharp's notice dated 10/23 of 2020. It was actually filed, or e-filed 10/24 of 2023, giving notice of intent to impeach by conviction greater than 10 years pursuant to 24-6-609. So it seems like the notices were in fact given timely. I'll include it as the next court exhibit in order. The only thing I have to do is do a 403 balancing test. So is there any reason why they wouldn't necessarily be prejudicial? Is there any reason why they wouldn't be more probative than prejudicial? Prejudicial and probative, I should say.
Yeah, I would ask for Mr. Steele and Mr. Steele either or to make Mr. Steele and Mr. Shard make the argument because they're asking for a compounding of it. We believe that it is that these are more substantially prejudicial than probative. And so I would ask for them to propound their argument so we can respond.
Yeah, I have to consider that as the last thing for the convictions that are over more than 10 years old, unless they fall into the category of criminal falsity or
I understand, Your Honor. I would say, though, I think we have to also analyze what I just announced about the two convictions. Those are not over 10 years old. Based on the plain language of the statute, also, this is my notes to these cases. So, but it's service of time for parole violation counts as confinement for prior convictions and calculation for the 10-year period. That's U.S. v. Gray, 852, Fed 2nd, 136. It's a 1988 case out of the 4th District, in U.S. v. McClintock, 748, Federal 2nd, 1278. It's a 1984 case.
Do you have anything more recent from our Supreme Court?
I don't think it's really
from our Supreme Court that's talked about the date of incarceration. I just wanted to know. I mean, I'm familiar with the rules in general about and being incarcerated and not completed those particular periods of probation extends the time. If you have a probation revocation, that extends the time.
Right.
So it's upon completion, which is ever greater.
So, Mr. Weinstein to the rescue. Williams v. State, 302 Georgia 474 at 482. And that's a 2017 case.
Williams versus the state?
Yep. Yes,
what
Your
is
Honor.
it again?
302 Georgia 474, I believe his handwriting is, or is that not? 474 at 482, and that's a 2017 case out of the Supreme Court of Georgia. I believe is going to stand for that same proposition. And as I said, that would apply to 12 SC. If my understanding of the court records, we pulled these cases and pulled the probation revocations for these cases. That would apply to 12 SC 110195 and 12 SC 113315. Those would now come within the 10-year time limit. And
it's a statute. Is it defined?
Yes, and also, Your Honor, just a plain reading of the statute, it defines time limit, and it says, evidence of conviction under this code shall not be admissible if a period of more than 10 years has elapsed since the date of the conviction or of the release of the witness from the confinement imposed of such conviction, whichever the later date, unless the court determines in the interest of justice that the probative value of the conviction supported by specific facts and circumstances substantially outweighs the prejudicial effect. So the time limit is, the plain reading of the statute says either the date of the conviction or release of witness from confinement imposed by such conviction, whichever is the later date, which is why I think that probably this isn't litigated that often, because the plain language of the statute is pretty clear. Your Honor, I'm sorry.
No, I'm good.
Okay.
Your Honor, and Mr. Sharkin showed it, I believe, and we're just double checking right now. The 1-1. We would agree with the 11315 because it looks like he was revoked and required to do 6 months on 12/18/2020. So
Right.
if he was in confinement, even if it was for 6 months, 10 years would be 2030. However, and what we're double checking, Your Honor, is on 12 SC 110195 that the probation warrant was canceled in March of 2015. So we're double checking to see if it was actually revoked on a 1.
If this helps, on the 195, my notes, and we have a big pile of papers back there, but my notes say the probation was revoked on 2/21/15.
That's what Mr. Steele's motion indicates. Plea was on 12 August of 2013, probation revoked on or about February the 21st of 2015.
In all candor, our motion is based on, it's the same source as my notes, but yes, that's our belief.
So we're looking at Odyssey. That's what we're double checking. We don't see an order. We see that a warrant was canceled. That's what we're looking for, to see if there was an order for the probation matter.
I'm just going to
Yeah. So what we have in Odyssey is that there was no revocation for 12 SC 110195.
Mr. Steele, do you have any documentation showing there was in fact a revocation?
Well, we don't have access to Odyssey, Your Honor. And that's the.
Where did you get the date, though? That's fine. That's why I'm trying to find out. If you put it in plea, so do you have some document to rely upon?
I see this. The state has shown me a probation warrant cancellation. So the question is, I'm trying to figure out if it was revoked even for time served, it would fall under the 10 years. I would just ask for a little bit of time. You know, the state kind of decided to address this now. I'm not blaming them, but we didn't really know that this was going to just be addressed at this exact moment. So I would just ask for some time to look into the clerk's file and try to figure out where we got that date from. Clearly, we got that date, and you know, perhaps it was just seeing the probation warrant, but you know, I wouldn't concede that point. And then the state said that they're going to email what they have on Odyssey, which we don't have access to. I'd assume we probably went to the public computers in the law library and tried to do it through there.
All right.
So my understanding where we are right now, the 3315, the state has conceded that falls within the 10 years, so that's not on the table. the 0195 may or may not be on the table depending on what we learn about that case. But for the ones outside the 10-year, we did give timely notice.
You did.
And so that's going to be a balancing.
So tell me why they're more probative than prejudicial at this point in time.
Well, for prejudice, it's a bit confusing to me because I don't know who would be prejudiced by the truth about Mr. Copeland's prior convictions coming out. Certainly he wouldn't be prejudiced. He's been given immunity. He's not a party to this case. So I don't really see any real prejudice. But the probative value towards his credibility, first of all, I'd point out that one of these cases, 09 SC 82479, not only involved giving false info, which is very probative of one's credibility, but also involved a theft. A car theft. Thefts are viewed as more probative to credibility than other non-crimes that involve some level of deceit or dishonesty. So the fact that it's a theft makes it particularly probative towards credibility. But also, Your Honor, Mr. Copeland is the key witness to a number of acts in this case. He's really one of the key witnesses in the case, if not the key witness. His credibility is the crux of this case. He's the linchpin of this case. I anticipate that he's probably going to be on the stand for a week or more. So one of the factors that we take into account when we're doing the balancing test is the importance of the witness's credibility towards this case, and his credibility and the ability of the jurors to consider his entire history, his entire criminal history is paramount to assessing his credibility. And I'll point out, Your Honor, one other thing that I think is relevant towards the probative value of credibility. If Mr. Copeland was someone who, say, had an 09 SC 82479 case and had a conviction, and then, learned from that conviction, turned his life around, went about, got a job wherever, was working, taking care of his children and taking care of his family and just living a law-abiding life, I think the argument would be stronger for it lacks probative value. But he hasn't done that. He's continued to commit crimes, to violate the law, to lie, to commit crimes indicative of a lack of credibility. So this tells the whole story. And I don't know why we wouldn't give the jurors the whole story about a man's history and his lack of credibility when his credibility is ultimately so important in this case. I don't know what he's going to testify to, but I do know that there's a possibility that things he said are going to come out. And the jurors need to know, can we believe this guy or not? And they need to have the full story about Kenneth Copeland and his criminal history.
All right, sir. State, you wish to respond, or?
Your Honor, I don't believe them having the full history is what will determine his credibility. They have now 5 convictions that they can impeach Mr. Copeland on. The issue is he a convicted felon? He is, and they have 5 convictions. These other 4 from 2009 and 2010 would be substantially prejudicial in this case, given that they have more recent charges for which he was convicted of. These charges, again, are theft by taking. They already have a a theft case that they can use to impeach him if they choose to do that. The other one is an ag assault, and the other is an entering order. I want to be clear that there is the 10 SC 87662 case, which he pled to a misdemeanor, which they could not use because he only got 12 months in custody on a
Is that
theft.
the one, theft by receiving stolen property?
That's the theft by receiving.
10 SC 87662?
Correct. So the three indictments that we're looking at, I believe, is 09 SC 82479, 10 SC 96938, and the 12 SC 110195.
What about the 9 CR 35? And then there's 44. It's 44. 44.
09 CR, that would be a misdemeanor because that would be solicitors. If it's 09 CR, that would be a solicitor general's case.
What about the 09 SC 82479?
Yes, Your Honor. So the three cases that we're looking at, Your Honor, is 09 SC 82479, 10 SC 96938, and 12 SC 110195.
No, they usually bring that up. Yeah. She has to do that with Nick. She didn't do that. She didn't do that.
In response to what the state just said, I would just reiterate when they talk about prejudice to who would be my first question. But also, Your Honor, regarding the misdemeanors, the state is suggesting that there's a ban on misdemeanors if they're not felonies. But I would point, Your Honor, to 246609A2, which reads evidence. This is what can be used to impeach as far as convictions. It says evidence that any witness has been convicted of a crime shall be admitted regardless of punishment if it readily can be determined that establishing the elements of such crime
in excess of 1 year. So it's got to be in excess of 1 year. For misdemeanor, that's why misdemeanors are usually disqualified.
I'm sorry, Your Honor, where are you seeing excess 1 year?
24-6-609 for purposes of attacking character, untruth.
Right, but under A2, not A1, A2.
A2
allows it's for crimes of dishonesty. The elements of such crime required proof or admission of an act of dishonesty or making a false statement.
Yeah, but what are these misdemeanors?
They're misdemeanor theft by receivings and thefts. Those are dishonesty.
Okay, all right.
So I just wanted to say, so I don't agree with the wholesale just conclusion that misdemeanors are not admissible.
Okay, so the misdemeanors that involve theft,
we
the court is of the opinion, I would agree with you, that they'd be admissible.
Right. And so...
Because they're dishonesty.
Yes, Your Honor.
Because they're dishonesty. Say shaking their head, but no, they're dishonest.
They're dishonest. All right. So.
We have a case line. We have a case line.
Well, then stop. Then come on. We're bring it. Stop sitting back there and holding your tongue. Then tell me what it is.
284 Georgia Appeals 534.
Say again.
Advocacy State.
Hold on.
In my opinion, the judge does everything he can to try to help this state and try to practice from the bench. But they keep falling short every time.
Go ahead. What is it?
284 Georgia Appeals 534. And it says for impeachment purposes, crimes of dishonesty were limited to those crimes that bear upon a witness's propensity to testify truthfully. Accordingly, misdemeanor theft by receiving stolen property was not a crime involving dishonesty.
Yeah, that's what it says, Mr. Sharp.
But the given false name is, so.
Given false name is?
Yes, sir.
Yes.
Okay. That's a 2007 case, which I believe is under the old evidence code.
And
it also has, I'm just trying to, it's got a big yellow triangle.
Shit.
One of the things I've also noticed about this trial, that the judge allows the state to use all case law from any state or from the Supreme Court, but he limits his case law to the defense. Basically, it has to be from Georgia. And if it's not Georgia case law, it's pretty much not going to be used.
believe that anyone in defense has a copy of the immunity.
And take you. Anything else I need to take up with you all before Mr. Copeland comes, testifies as our next witness?
Yes, Your Honor. Two things. First, I don't believe that anyone in defense has a copy of the immunity, the order granting immunity. I believe that we're entitled to that, so we would ask for that. Additionally, Your Honor, we are going to diligently, over the lunch hour,
I don't know who this person is, but they say what I say up all the time. And that is, the judge is practicing law from the bench illegal. He made Woody commit to what is called rush to judgment. I believe that.
Myself and other counsel look at these state's exhibits. Last week, we discussed that we had some objections to, if you recall, and we kind of put a pin in it because the state said that it was just a large amount and they were going to narrow it down what they were admitting or seeking to admit. Well, now we have a PowerPoint. It looks like they redacted some of the things that were going to be our concerns. But I'm just going to ask, I hope Your Honor understands, we just received this and we're going to, over lunch, look at the proposed exhibits. And if we have any specific objections after their redactions, we'll bring that to Your Honor's attention, if that's okay.
That's what you told me, so I certainly understand that.
Right. So what happened since that hearing or that discussion was the state did make some redactions, and I think that addressed possibly all of our issues, but at least some of them. But we just received this, so we'll report back to the court whenever Your Honor wants to.
Okay, but remember, our jury's been here since 8:30.
No, I understand that.
So I'd like to kind of go ahead and get started.
Well, if Your Honor wants to go through these one by one, we can. We just literally.
Oh, you can do that during lunch. That's fine.
Okay.
I mean, but this is, I know that you all we should have been working on these prior to that. So, okay.
Yes, we just got this.
Okay, but you had the larger exhibit for the.
And we brought those to your attention last week.
Yeah, I remember.
Okay.
I remember. Okay. All right. All right, Deputy Ham, summon our jurors, please. Oh, we're waiting. Where's Mr. Melnick? And Mr. Copeland? He's waiting. Okay. All right.
I want to thank you too for the cash apps that I received. I didn't realize it because I have my phone volume turned low. I will acknowledge you once I take the big screen down, but we're finna get into some real good stuff in a very few minutes. So thank you very much for the cash apps that I received.
Your Honor, Mr. Melvin is gone for about 30 or 35 minutes.
Can we call him, please? Or tell him that we are going to need him back for 1:15? All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen of the jury, good afternoon. Good afternoon. All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Ken Copeland to the stand.
All right, summon Mr. Copeland, please.
Your Honor, here is that Mr. Copeland is.
All right, here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face.
Now, wonder why did Joanna stop her when she said, Joanna, it seems like Mr. Copeland is, and he said, and then Mr. Copeland came. Wonder why did he stop her? And y'all gonna see why I asked that question right in a few minutes. But I'm just gonna try to rewind that just a little bit so y'all can hear that and tell me what you guys think after you see what happened, if you haven't already seen what happened. Why do you think he stopped her from saying what she was about to say? Because we don't really know what she was about to say.
All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. They're introduced. So.
Everybody ready to?
All right. Summon our jurors, please. Okay, all right.
John, just a reminder, there are some issues with the closing. I don't know if the state plan that today, but I just want to give you a heads up.
Your Honor, we're going to pass them out, and I think we can deal with them after.
Okay, all right. She said you'll deal with it. She'll deal with them as they come, as they're introduced. So.
Everybody ready to?
All right. Summon our jurors, please. right, sir. All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen of the jury, good afternoon. All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Kenneth Copeland to the stand.
All right, summon Mr. Copeland, please.
Do y'all notice how she said that in her facial expressions and how she's looking as if she's utterly disgusted? You'll see why I asked that question in a moment.
Your Honor, here is that. Mr. Copeland is.
I just. Here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Ham to be sworn as a witness.
You swear affirm the testimony to everybody get reported the truth, the whole truth, nothing but the truth, help?
Yes.
Maybe see if you state your first and last name with the spelling of both, please.
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
K-E-N-N-E-T-H-C-O-P-E-L-A-N-D.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From.
All right, sir.
Mr. Copeland said he was grown, he was an adult, and he pleaded the fifth. Now, in my opinion, they all knew this because of the way she started out. Number one, I think I've heard her ask somebody did they want to be there, but she asked him, did he want to be there? Then she asked him will he allow her to ask him some questions? Then she asked, how old was he? That's not germane to this case at this point in time, in my opinion. So to me, she asked those questions because she knew he was going to plead the fifth. And they can't allow the jury to see a person plead the fifth with this type of immunity. So what she did was ask the question to test the waters. And they knew that he wanted to plead the fifth. He must have understood over lunch, because I believe he thought when the judge said he got to say what he got to say, that meant that he could say that. Maybe that's not what he understood. I don't know the operations of his mind. But I know a lot of these young men were on a lot of drugs, and they did a lot of crime, and they don't have a lot of education. So their comprehension level is a little less than mine. And I don't have much, but I kind of understand a little bit about law, a little better than them. And so he might not have truly understood. You know, they asked us, do we understand? And we say yes, and a lot of times we really don't overstand, understand, or understand what's being asked of us or what's being said to us because we don't know legalese. and we don't know that we may be saying something that we ought not say. But anyway, let's go on with how the judge is going to treat this situation and not against the state.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take them into custody.
Now, we all saw the judge looking up all the different case law when they were talking about those cases before, they took the lunch break when they were talking about his prior crimes and things like that. What are the chances that the judge would have waiting for him on his computer what to say to him under what government code, because he was looking at the computer, if he were to take the fifth? What are the chances of that? He knew once he got through looking up all those other cases just to put that on there just in case? Or did he have prior knowledge? The way he's going to respond, it would make you believe that he had prior knowledge. And the way he take ownership of what we didn't know as opposed to what the state didn't know makes you know that he had prior knowledge. It's amazing how this is going. And thank the two of you for still being here. Let's listen.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take them into custody. Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Colton was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No, so the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record regarding Mr. Copeland. As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may...
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So could you sit down? Is it time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland, May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it.
So why didn't she object at that time? And why didn't the judge see it? And why didn't everybody else see it? I want y'all to know Infamous Sylvia showed a video from her camera that showed the whole time that Mr. Melnick was in the courtroom. And you will never see him and the defense attorneys looking at each other, talking to one another. And I certainly didn't see him stand up there and shrug his shoulders like I tried. I'd never seen any of that. He came there telling them they spoke with his client without contacting him. Then they came up that morning and got that immunity deal so that they could make him testify after subpoenaing him twice. And now she's up there lying, and the judge is just going along with this. Everything else is hearsay, speculation, conjecture, but he's taking this as if this woman is telling the honest to God truth. And so let's just keep going, because it's going to get a little rough.
Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in time tell you? Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in, regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Miss Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses. This particular witness on the part of...
She's not saying they're tampering with witnesses. She's saying that his own attorney is tampering with a witness. But I want to just read this. It says, Woody has effectively gotten over on the prosecution. Someone said, oh man. He said, I am here, ain't I? You can't make it up. Shaking my head. Where the proof of all the stuff she's saying I'm going to add? Gutter snipe trash. Defense taking L after L. The DA intimidated the witness, and they knew that he was going to plead the fifth. This prosecutorial team is not playing by the rule of law. They are making up rules of their own, and that is true as they go. And it is unbelievable. Done deal. Smart move by DA. Judge is going to let Woody sit in jail over the weekend. That is so funny. Well, they said over lunch that Woody went on Instagram, and some people have it. They have a Snapchat picture of his Instagram post where he told everybody he was about to go to jail. He was ready to go to jail. He know he's going to jail. But he's going to jail now knowing that he's going to be all right, rather than going to jail under the manner in which they want him to go, knowing he could be in not only federal custody, but something could possibly happen to him. He is the one who has to live with his decisions. She can't compel him, as she thought, to testify. And he thought he was testifying according to what the judge told him he could say. And this is where he ended up. So here we go.
People who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks, and after Mr. Copeland has communicated to this court, he will testify. So why?
Now, when the crooked officer Gaither was there, she said, and I say crooked because she was proven to have lied. I saw that in the videos. I played it myself. She hasn't been arraigned for it. She hasn't been charged by any law, but that's just my personal opinion of her. And I I can prove the lies that she told because I have them on video. But when she said that she talked to them every day and every day throughout lunch and everything, nothing was said. But now she had to purposely put on the record that who he's talking to during lunch. Now remember, this man just found out about what they were doing to his client the day before, Thursday evening. And then they ran after he sent them that email. So you know that they're disingenuous because they didn't offer him immunity until his attorney contacted them and told them that y'all know you all are wrong for talking to my client without contacting me. But let's keep hearing what she has to say. They think that dogma really works. That angry black female, as they love to call them. It doesn't work.
Watching the goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us.
She said he asked to speak to Miss Hilton, but Mr. Melnick kept going back in there and going back in there as if he wasn't supposed to be in there with his client. That lady sounds utterly ridiculous. And this judge is actually sitting up there just listening to her as if she's making some type of sense. I seen where someone said, love is just mad. Their case is falling apart. And then someone said that she knows that she's been caught lying. Everybody's telling her to take that G girl and sit down. Witness tampering. She knew. And she did know. She's not going to ever make me believe she didn't. The way she announced him and the way she looked. And when she looked when he walked by. Utter disgust. And then she told the judge that they said they was going to hammer him. Who said that? But he wouldn't let Mr. Steele call the people who heard him say out in the hall that he was not going to testify. Someone said Woody won't be tricked. No, they was trying to hammer Copeland. That's what they were doing before lunch. Yeah, thinking he wouldn't have to testify. Expose it, Miss Love. I knew the defense was tampering. That person sounds crazy as all New York. Going to jail is some smart move. Get a life. Witness tampering. Backfired on the defense aides, they say. I don't think that backfired at all. They big mad and now she reaching. The man did what's best for him. He's the one facing federal charges. The defense is not facing federal charges. They're facing state charges based on a false premise of RICO. This man actually has some federal charges that he could get picked up. And remember, he had some federal issues that he didn't go to jail and prison on. So y'all gotta know. This is crazy. I'm going to read a couple more and then we're going to get back to the video. Okay, well, it's on his social media that he wasn't going to testify. Yeah, they said it was deleted, but he did put it on there. Ural is wrong. Let love talk down on lawyers. And then when he does correct supposedly her, he's always putting it on y'all all as a collective, as if other lawyers are doing that to her. Why she didn't say before Woody came in? I believe she tried to and the judge stopped her. But here we go. Let me get on mute so y'all can hear this, because this is interesting.
Us to call into question whose interests he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know, I guess they're, you know, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland, because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. And I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interests of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are, because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney. I guess he told him that, I guess the state's going to hammer him. I don't even know what, but Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial, Mr. Steele, at this point in time. I'll note that you've made it. I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this, but there's a great investigator who is looking at me and I trust her. I'd like to call her to witness. I was told I was not there. I was told that, and I forget her name, I know her first name, but her last name. And Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up. And then the Honorable David Botts told me as I was walking in that he heard, he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, if I said the wrong people, please correct it, that he's invoking the Fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements, okay? So I'm going to...
Reminded all the time because I live them. I'm just telling the court that in order for you to deny my motion for a mistrial, this is bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time, okay? In terms of this motion for mistrial.
Well, I would like to call the witnesses, but I understand what you're saying.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine, okay?
When they doing that, he's abusing his authority and practicing from the bench. Because if he called witnesses, they would have to swear under the penalties of perjury. And that's what they're avoiding. And that's what we have to understand, the trickery in the things that they do and why they do what they do. Because we don't really understand law, we take everything emotional and personal, but we have to really start understanding what's happening before our eyes. And then we got to ask, those pertinent questions. What, when, why, who, where. We got to ask those kind of questions.
Can I add a property line?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach, and I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. My belief, agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making a...
How do you know it was on the phone? If it was Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular purported conversation?
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was having no interactions with...
Okay, but here's the thing. I think it's consistent with I'm not testifying, okay? He can make a decision not to testify, okay? But if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is...
I believe that the state was on notice that something like this is going to
Okay, all right. But all of you have kind of, like I said, either unwittingly or I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences, influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. These witnesses will testify to whatever they're going to testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but I did.
I've heard is the state.
I didn't say you did anything wrong, but
I understand,
okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we.
I don't know of any defense counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. Today, I don't know of anyone that's had conversations with...
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer. And that lawyer can make that decision, and so can Mr. Copeland. So
situation because
I understand that, but you can't let other people, and I would advise you not to let third parties.
Now, he's telling all this to the defense, who hasn't ever talked to the witness. But he ain't saying none of that to the prosecutors, who he knows now spoke with the witness without speaking with his attorney or without the client speaking to his attorney. Judge Ural is really warped. I mean, he is biased. He is prolonging this trial, just like he's saying the prosecution is. And again, nobody is not going to make me believe. People can believe what they want. When I heard in the Senate committee meeting, all of the monies that these people get for their budgets, and then they can change their minds once granted all of these millions of dollars, they're not going to make me believe they're not using the longest trials in history over what? These guys, mostly all of them, have already been incarcerated and done their time. They were criminals. They were children. They were young adults. These guys have nothing to do with each other, but they brought them together because they use the initials YSL in their name, on their body, however they do it. Be careful. I try to tell people all the time. They could do the same to any of us. But I try to tell them all the time, be careful on this social media. It's a digital footprint. And they may not spend any money to look up yours unless they come up with something like this. This is really, really, really egregious. This is horrible. And this goes to show you again, doesn't matter the ethnicity. These people claim they have children. So when they see these children, they should see themselves, because that's what happened with other ethnicities. And that's why they don't get hunted down in the streets like we do. But not these people. This man reminds me of the wicked judge who feared not God nor man. But this woman kept coming to him, and that reminds me of love. And she kept nagging him and nagging him and nagging him until he pardoned her, because he allows this loved woman to get away with. The behavior is not professional. It is not. And then he give all these lectures to the defense, and he won't even let them speak. So let's keep going so we can hear the rest of this craziness.
Influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay?
Okay.
All right.
Judge, I would like to hear.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland, and I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position.
Someone wrote, he let Miss Love speak uninterrupted, but soon as defense speaks, he's trying to cut them off and accuse them of something. All defense lawyers ask for you to leave. WTF. And then someone said, look at Woody's last post. They knew this man was not. They've been looking at their social media all this time. You want me to believe they wasn't checking it during lunch? Yeah, they were. Here we go. Thank everyone for joining us. Please hit the like button.
Where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal. I
don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the State Bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute is pretty clear.
I understand.
And I know you, and I know you have known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that as you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go. Go ahead and I'll call him out before the jury comes in on Monday morning. We'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunities. So he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
That's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton and Miss Love in particular for a long period of time, and I don't think that they would do that to you.
Someone said, I am just so baffled that Love can really sit here and make the statement she just made when she literally sent an innocent woman to jail and bully her on the stand. Girl, bye. Same answer, Judge. Last laugh, Love. When being slick goes wrong, and tell Woody to stand 10 toes.
Judge, at no point did they ever reach out to me about Mr. Copeland.
Your Honor.
about Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness. Because
When did you talk to?
Now, remember I told y'all to write down when she was saying, I believe. I believe. I believe. Now she's going to be emphatic that he never told her. And then he told her he wasn't. Then she's going to say Love told her he wasn't. So just listen to how she's changed from when she was bringing it to the judge's attention at the very beginning. The state has really made many kerfuffles in this case. Just listen.
Mr. Copeland.
last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us again. We showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and that my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may.
So now the judge is saying the witness is not truthful and he's a liar. And he's going to go with the state.
May not have thought that he potentially needed you, and as things developed, Mr. Melnick, he decided, well, yeah, he does need you, but whether or not.
And answer my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay?
Of course.
And that sometimes has to be explained to witnesses and clients. Okay? All right. So that's where we are at this point in time, is that Monday morning I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up, because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland, that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Now, Ms. Hilton just said that Ms. Love told her that Mr. Melnick was not their attorney. Now Ms. Love is saying that's not what Mr. Copeland told them. It's amazing how this judge let all this stuff go, and this is all on record.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday. And we'll see where we are at that point in time. Okay. And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay.
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel, and now you are, you have put us in a situation where now, you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my
then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is. And I need to know who that lawyer is. Do you want to have a conversation with him before?
I'm going to talk to him right now.
All right, okay. I'm going to allow you to do that. And then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please? All right, and I'm going to go ahead and at this point in time, summon our jurors, please. All right. And but if not, we will be here on Monday at 8:30. Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file.
To be able to play
To be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under headings. With some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. Okay. And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do.
I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Can we strike the hominem attacks? Really? Can we strike that?
Okay, hey, everybody, calm down. Everybody, both of you sit. Both of you, please be seated.
Judge, I'm not.
Both of
done.
you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the case.
But Mr. Steele.
I asked you, please.
Mr. Steele.
How would you feel if you were being treated
Mr.
like
Steele.
this?
Mr. Steele.
I'd like to finish.
Mr. Steele.
I gave him everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But they're...
And Mr. Williams, to me, this is an innocent man. You talking about, Miss Love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to the ad hominem attacks, and I ask
all because she wants to win the case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by this way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now. And I wait there and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it. And you have told him in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I object.
Try to silence me. I will not be silenced.
But Mr. Steele, here's the thing, okay? I think that, Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir, please be seated.
Whatever you do is fine, but I care about Jeffrey Williams. It's the best.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious.
I'm not going to play what he's saying there because it is so stupid in my opinion. It's so stupid because he's talking about maybe they didn't get all the information from the jail. Well, if that's true, that would be true for Mr. Steele as well. So he's talking about he can order the records for them and they'll send him the whole thing. What does that have to do with the price of tea in China? Nothing. He sent her what was sent to him. She's lying. And the judge just lets her get away with her lies. Before we say goodnight, I want to play the little gang member that tried to get out the gang.
He was first shot, then robbed, and he says it was...
He tried to get out the gang, but this is what happened to him. Okay, Bahara, I'm going to address that when I get to playing this. This is a little 2 minutes. I'll address what you said in just a moment. Let me play this little 2 minutes of a young man who tried to get out the gang, and the gang was not YSL. This YSL just came up when Fonnie Willis had an opportunity to bring these charges against a millionaire and someone. It is rumored, I don't know how true it is, that she and the guy that was unalived nut were lovers and dated. And they say that they have proof. I don't know if they have proof. I don't know if that's true. But we know rumors fly every day. They lie on me. So I can certainly tell of a rumor. One moment. Fair use, I'm going to thank again Fox 5, Atlanta.
Was all because he wants out of a gang. Now Atlanta police say they are offering a big reward to help capture the gang member who pulled the trigger. Tonight, the victim, Tyson Brantley, spoke exclusively to Fox 5's George Franco, who joins us live from Atlanta Police headquarters with the story. And George, did Tyson say why he wanted out of that gang?
Well, Deidre, Tyson Brantley says he has a new perspective in life since the birth of his daughter. But getting out of gang life has been no easy task. So you want out of the gang. And they fought back. 22-year-old Tyson Brantley is upfront about getting out of gang life, but that has turned out to be easier said than done.
It jumped me. I was walking to the store.
A few days after you were shot?
Yeah, 2 days after.
Brantley says he got robbed at this location not far from his home in northwest Atlanta in August. A couple of days earlier, he says he was pushed into a car at gunpoint at this Atlanta apartment complex and driven elsewhere.
Get me out of the car, he's pistol whipped me and moved me away from his car, shoot me in my leg.
Atlanta police say Antiba Daniel, who was with another man, Big Dog, pulled the trigger. APD identified them as members of the gang Sex, Money, Murder, or Mob, who retaliated against Tyson when he said he wanted out.
I just realized that nobody was really loyal to me like they said they were. So I had to move myself from the situation.
Police hope a $2,000 Crime Stoppers reward will lead them to arrest Antiba Daniel. Were they family to you?
They said they were, but they really weren't.
Brantley is now back home with his real family, his mom and dad, after a few years of gang life.
Or just pushing him to keep doing the right things and don't, waver and feel like you have to go back and backslide.
Which the 22-year-old says won't happen because he has a 6-month-old daughter now and education and job prospects.
You can get out. Like, you can change your life around no matter how low you are. It's not too late.
And that was his experience. And that was like 6 or 7 years ago as well. And then Bahara said the judge and DA got a trick move and railroaded Woody. They knew he had an attorney. So to avoid him, they did this. Hilton and Love are lying. It's all about phony political greed. I agree 100% with you. Yeah, when you start looking at these things, then you learn that a lot of things that go on is about politics. And since we have no real knowledge of politics, we're not interested. We're only interested in things that we tend to have knowledge of or think we have knowledge of. But it's way deeper than what we think. And we really need to start paying attention to what's going on. We really do. That's with the fact that the court stopped Fonnie Willis and that train that she claimed that was going to keep on rolling. She can't do anything. And they have a hearing set for October the 4th, but that may not take place. Then I saw a video of a young man, and he said that she took money from some other DA that was convicted of stealing money. and she took money from that stolen money. So she's, really just all enshrouded with corruption. And what I saw with the committee's meeting on the other day, I'm going to make a video about that because I was really, really disheartened by the Commissioner Pitts. I thought he was a halfway decent guy. I thought it was really strange that they don't know anything about these people's budgets and how they spend their money. They just know they come to them with line items, they give them the money, but then they change their mind, and then they say there's nothing they can do about it. I might be true, but I find that hard to believe. But in today's world, I guess we have to believe everything until, it's proven to be different. But he actually wanted to do some type of ordinance to stop people from coming to the chamber and voicing their opinion by using, some of the funny names that they use for some of those people they're mad at. And he honestly wanted them to come up with a law so that they can stop people from exercising their First Amendment rights. And to me, the only people on that board that spoke with some common sense were the Europeans. And then even the man Arrington, who is a part of the cultural corruption, in my opinion. He's the one that worked against the state representative. But he even tried to pull out Robert's Rule of Order and say that the Robert's Rules of Order could tell them to limit people to what and how they can talk. But that's for the body of the commissioners. Robert's Rules of Order does not apply to the public at large. So if we don't really understand and know what's going on, that's why we stay in the condition of a minority, a child. They truly believe that we don't have enough sense to handle our own affairs. And most of us won't seek the knowledge to show that we do. You don't have to go to court. You don't have to be in the courtroom. But you should want to know about jurisdiction and how it works. You should want to know about what governs you. You should want to know about the articles and the ordinances, which are all just, to me, a combination codified black codes. Law, in its very nature, is if I don't harm you and you don't harm me, no harm is done. Enforcement of a law comes when harm has been done. There are presumptions in law, and one presumption is those who have a right of claim and do not claim it forfeit that right. And as I've read from Silent Weapons for Quiet Wars, those who have a brain and don't use it are no better off than those without a brain to use. These are not just cute little statements. And it's not meant to hurt anyone's feelings, although your feelings could be hurt. But what does that have to do with you preparing children for the future so that they won't go through what we've gone through and those before us have gone through? We've lived long enough on dreams of somebody else's, on hopes, on broken promises. We have to do for ourselves. Learn the rules and start living life free indeed. Again, America is known for the home of the free and the brave. And I say it is the land of the free and the slave. We're freed out. Everything is going up but our salaries and our monies that we've worked for all of our lives and retire. A lot of those monies are being ate up. We're going to face hard times. We know that just by seeing what's happening every election cycle. And all kind of weird things happen. And it happens to buy us in. We have to know that colors really matter. Remember, they used to have a group that wore all white and capes and hoods. Now they come in red and white, pink and green, purple and gold, black and gold. And they look just like you and I. Their allegiance is to no one but themselves and their societies. They say that they care about the people. If that be true, why are we in the very condition that we're in every hood in America? And the hood is the urban neighborhoods where we own nothing. A community has ownership. We own nothing. All of our little mom and pop stores are gone. Maybe one or two. And that would be beautiful to see them again. Most of us don't know how to grow food. Most of us don't even know how to cut yards. We need to wake up for real. And I'm not talking about I'm walking around here talking about I'm woke. No, wake up. So that is my show for tonight. I just think this is so sad. And I hate that I don't get more people in here to learn this knowledge. Preferably somebody will look at it later. But there are many people, like I said, that cover this story. And they cover it in witty ways and they have great editing. All I have is me and my studying and my opinions. That's what I have and that's what I give. I've seen two people tell their chat to give for certain things. And they needed X amount of dollars, hundreds of dollars. And I mean, they actually got them. And I'm like, oh man. Just think if we all worked together. You know, they say support black businesses. I support many people on here, but I don't see them supporting me. So you have to support yourself and do what you do. And be true to what you do. Remember, my saying is to thine own self be true. And if you're true to yourself, you'll be true to everybody. I thank everybody who come to my chat and stay with me. I certainly appreciate it. I love it even more when you communicate in the chat. It helps YouTube see that people are really interested, even if it's not a lot of people. Those that are here are. So it helps when you talk in the chat. But I can understand some people not wanting to talk because I've learned the game of YouTube, and in some chats you can just say one thing and you can become public enemy number one. So you have to do that at your own discretion. I appreciate all the likes, all the super chats, all of the cash apps that I receive. I greatly appreciate that. And I look forward to seeing everybody back on Wednesday. And we'll do it again. Like I said, I may make one or two videos for the next couple of days as I lead up to whatever we're going to talk about on Wednesday, because there's so much to talk about. At Congress, I seen the other day where Melanie King did a video about the congressional hearing, and they were talking about, they were questioning Merrick Garland, the U.S. Attorney General, and his knowledge of Fani Willis and Nathan Wade coming to the White House, which of course he said he had none. But I'm going to make a video about that. I thought that was very interesting. It's so many interesting things that's happening actually worldwide. But these things here are very, very important. And I think they're important for us as a people because this is one of the cities that they proudly brag on that's Asiatic ran. And they make it sound like people are doing the right thing, but we see that they're not. They're no different than anybody else. Matter of fact, they're worse. Out of all the gangs, we don't see any of the other gangs. And I know they got to have other gangs. This lady said they had 145 gangs. I know all of them cannot be Asiatic. But we don't see anybody else in any of these indictments under these RICO charges. Why? And we see this because the two that they did do something about, there are young rappers that's making millions of dollars off of a creative pen and paper or a ghostwriter, and they have the ability to rap it to a beat. And they have friends, and they were once kids, and they may have done some bad things. But this stuff that they're doing to our children, we really need to pay attention. Pay attention. And on that note, I'm going to say thank you again to everybody that came by the Tiger's Den. And I'm going to get ready to close with my favorite song, Children Are Our Future. I pray that Young Thug soon can get bond. This is utterly ridiculous. Tomorrow morning, they're going to bring Woody back to court. And he is supposed to plead the fifth. His attorney is out of town, but he's going to have representation. And his deal is he's going to plead the fifth because he knows what talking will do to his future. And it has to do with his freedom. And I think he can take whatever he needs to take for the duration of this trial compared to possibly going away for the rest of his life. I lift up all of the people involved in this case. The wrongdoers, I hope that they will come to their senses and do right. The right doers, I hope they continue to do right. And I hope they get the results that they seek. And we got to pray for our country. Pray for everybody. And I mean prayer by speaking good words, affirmations, life into people. Don't just pray on them, P-R-E-Y, and suck the life out of people. The law of reciprocity is real. And we do reap what we sow. On that note, I'm leaving the Tiger's Den. Thank all the newcomers for coming. And all of my subscribers who've been with me, thank you for returning. I greatly appreciate you. I really do. And I'm going to say goodbye. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, At least I'll live as I believe, no matter what they take from me. They can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.